We will go on the record in the matters 25 CF 89, 26 CF 09, State of Wisconsin versus Timothy Anley. The state appears through Assistant District Attorney Jose Vila in person. We have Defense Counsel Zachary Fisher in person with Mr. Anley in person in custody. We're set here today in this matter for a couple of reasons. We're here for a final pretrial, a preliminary hearing, a bond modification hearing, as well as the court has been informed that the parties have reached an agreement as it relates to 25 CF 89. Is that all accurate and true, Mr. Fisher?
Yes, Your Honor.
All right, so we have multiple things that we need to accomplish here today. First and foremost is we will start with the preliminary hearing. It's my understanding that is a waiver.
Yes, Your Honor. I have discussed that with Mr. Anley, and he's prepared to waive that today.
Do you have a form, or do I need to go over the colloquy?
If you could do a colloquy, please.
That is totally fine. All right, Mr. Anley, do you understand what a preliminary hearing is?
Yes, I do, Your Honor.
And do you understand that the state has the burden to prove a felony was probably committed and probably committed by you?
Yes, ma'am.
Do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can meet that burden?
Yes.
You understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you. He would also be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. But for today's purposes, you're giving up those rights. Do you understand that?
I do, Your Honor.
You understand that if at that preliminary hearing, the state cannot meet its burden for any of the felonies, I could amend them to misdemeanors or dismiss them altogether. But for today, you're giving up that right.
Yes, ma'am.
You understand that as a result of waiving your right, the matter will be bound over to future proceedings, which could include a trial.
I understand.
Do you understand that once you give up the right, it's forever and you cannot get it back?
I do.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
I am.
And voluntarily?
I am.
All right. I will find that you are incompetent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I'm going through and filing the information as we speak. It will mirror the criminal complaint.
Here's the criminal complaint. Does he understand those charges?
Yes, Your Honor. I would ask to schedule out for an arraignment.
All right. All right, we can do that. And I am not quite certain that we're going to be able to get a plea and sentencing done here today, because I do have a visiting judge who is scheduled.
She'll be.
She could, but then Mary told me that she may need this room. So she is scheduled for 9:30. So I'm not sure if we can get through a plea and sentencing, but I would be able to schedule it as early as Monday.
As long as the court is okay with that, knowing that I would probably have to appear by Zoom now that the plea questionnaire has been completed, I'm comfortable with that.
I would be fine with that if Mr. Anley is fine with that.
We can still ask for but in terms of this.
And you would be fine with that?
I'm fine with that. Yes,
And
ma'am.
also, Mr. Fisher, before I received notice about the plea and sentencing, the court did consider your request to have this possibly be a global resolution. That is something that the court would consider. So I'm not sure if there is any negotiations here going on, or if something of that matter. Otherwise, we can proceed as we are planning on Monday, but if there's a potential for a global, I am open to that as well.
And I can discuss that with Attorney Vila later this afternoon. I guess I would just obviously want probably the trial to come off then, just given the time.
Would.
Okay.
Yes. I can definitely do that. And I know you would need to discuss that with Mr. Anley because that affects it one way or another. So we can have the arraignment on Monday, a potential plea and sentencing, or you can update the court of whether or not this could possibly be a global resolution. And I'm not sure where the other felony is going. I don't know if there's any motions. I don't know if there's anything else that that would be occurring. But I do have in the next couple of weeks places where I could put it if it is able to resolve quickly. Or if we need hearings on motions, I could slide them in quickly because I do have gaps here and there, which is unusual, but I do. So I wanted to update all of you on that. I know we do have victims here and they wanted to make a statement as it relates to the bond hearing, but I will also hear the bond hearing on Monday, or I could hear it today, but quite honestly, it all depends on what's happening with the cases. Okay.
Yes, Your Honor.
So is there anyone, do you want to make any statement on the record? Do you have anything that you want to add, Mr. Vila?
No, Your Honor. I would just like the victims to be heard if they really want the bond
Yes.
hearing to go forth today.
I was going to ask if, even if they don't want the bond, even if we're not proceeding with the bond hearing today and it's going to be Monday, they can still make a statement here today. Mr. Fisher, you can talk to your client.
Yes.
Your Honor, if we could just proceed with the bond hearing today then.
Okay. All right, so we do have a victim who wants to make a statement. Please state your name if you wish, or just your initials.
Rachel Hess.
All right, you may begin.
Your Honor, I ask that the bond does not get modified for the safety of my children and myself. Over the years, the abuse has just gotten worse and worse. And when we have contacted law enforcement, we haven't gotten the help. So I do fear for my kids' safety, especially Noel.
And you can use initials for minor children.
Okay.
Okay, and so NA, is NA a victim of this case?
Yes, Your Honor.
And is NA, well, an alleged victim, sorry, I have to say that. Is NA an alleged victim of the new case?
Of the new case, yes.
What about for the new case, but what about the older case too? Because that comes into play too, the 25 CF 89.
That would be our son, Logan.
And is Logan here?
Yes, ma'am.
Logan, do you wish to make a statement today? No. Okay, thank you. And it's my understanding that Logan is no longer a minor.
That's right.
Okay, all right. Anything else, Ms. Hess?
No, Your Honor.
Okay, thank you. Okay, Mr. Vila?
Thank you, Your Honor. I've had a chance to review defense's motion to modify bond. State believes that bond should remain the same in this case. Mr. Anley currently faces 3 counts of felony bail jump, 1 count of physical abuse of a child intentionally cause harm, and 1 count of felon possession of a firearm. All total together, he could be looking at north of 15 years of initial confinement if convicted on all those counts. Mr. Anley was out on bond on another case in Polk County, specifically 24 CF 191 at the time he committed to these new crimes. The concern here is that despite being released, he continues to violate conditions while on bond. When considering those totality of the circumstances, I would ask for bond to remain the same. Thank you.
All right, thank you. Mr. Fisher?
Your Honor, I would ask the court to consider reducing the cash bond in both of these files. At this time, Mr. Anley has posted $3,000 on the underlying file. He would be able to post potentially an additional $500 if the court was to modify the bond down to $3,500. Otherwise, he would not be able to be released. It's my understanding that he is a local resident of Grantsburg. He is a homeowner. He has not missed any court appearances that I have been aware of in either Polk or Burnett County. At the time of the new alleged offense, Mr. Anley was in a treatment facility for alcohol abuse, and he does deny several of the allegations in the newest case, and he does intend on fighting them at this time. And I believe there are separate ways to ensure protections of the public and the alleged victims at this time. It's my understanding that there was recently a restraining order filed again by the alleged victim and one of the children against Mr. Anley. Additionally, there are bond conditions that the court has set in preventing contact. There is also a guardian ad litem that's been appointed that can make additional inferences and statements in terms of what they believe should be appropriate conditions for protecting the children in this case. And I don't believe that Mr. Anley, and given that the alleged firearm that Mr. Anley did have in his possession.
Probably not go down that road, but you can.
Yes, Your Honor.
You can, I'm not meaning to jump on your argument. I just don't want you to say anything about the gun if you don't want to, but you can.
I understand, Your Honor, and I understand where the court's coming from. I would just state that I believe that at this time, Mr. Anley does have things he needs to attend to at his home. I believe, no contact conditions as well as the restraining orders and any conditions that the court believes appropriate would be enough to ensure protection of the public in this case. And I don't believe he is a flight risk. It's my understanding that Mr. Anley does have a sponsor. His name is Reed. I believe if Mr. Anley was released, it's his intention to go straight to an AA meeting with Reed. He understands he has a drinking concern. He doesn't deny that, but he believes that he can maintain sobriety and reach out to support groups in the community if he was to be released.
Okay. The court is very familiar with Reed. He is a sponsor with a lot of individuals that come through the court system and primarily my treatment court. So I'm hoping that that is something that is accurate and true of a statement. Anything else you want to add?
No, Your Honor.
All right. The court is taking judicial notice of Polk County case 25 CF42, 24 CM92, 24 CM191, and 23 CM193.
What do you think? Did the judge strike the right balance? The defense pushed for a much lower bond, arguing Timothy Anley had community ties, treatment support, and no missed court appearances. But the court looked beyond just the risk of flight, weighing the allegations, multiple pending cases, and the safety concerns raised by the alleged victims. In the end, the bond was reduced, but only from $18,000 to $10,000, showing the judge was willing to compromise without ignoring the seriousness of the accusations. And with both sides still discussing a possible global resolution, this case is far from over. Let me know in the comments. Was this a fair decision, or should the bond have stayed exactly where it was?
In addition to all of the other matters before the court, and the court is also taking judicial notice of Polk County GF or 25 GF 260. It is a group file. Apparently there is other allegations or something. I'm not sure exactly what is going on with that, and a ticket of 26 TR 02 operating while suspended. The Polk County matters are serious. We're going back to 23, which has allegations similar to these in Burnett County. 24 CF 191 Polk County, there's allegations of possession with intent of amphetamine, methamphetamine, maintaining a drug trafficking place, etc. 24 CM 92, which is allegations of resisting or obstructing an officer. 25 CF 42, it's 24 CM 92, 25 CF 42, OWI 4, or operating with the PAC 4, and those other newest allegations. Again, I don't know what's going on with the new allegations. I just see that there's something in the mix. The cases before this court today are, again, serious because they do involve alleged victims. And I don't mean, that's not disrespectful to anyone involved in the case. Mr. Anley is innocent unless the state proves him guilty on the allegations. So that's why I say alleged victims. There's alleged victims in both of our cases in Burnett County. And allegations of minor children being a victim, and or I believe Logan was a minor at the time of the first one, but I don't know for sure. I just recall that he, by his birth date, is of age right now. He was 18?
Yes, ma'am.
Okay. But he is one of your children. So all of these are serious, but I hear you, Mr. Fisher, when you are making the statement concerning the court has already placed bail bond conditions of no contact with Ms. Hess, children or residents. The court has also entered the child abuse injunctions. And at the time, the court did inform Mr. Anley of his right to remain silent because anything could be used against him in that case. And he, for the most part, did. And he did not want to incriminate himself or make any statements that could. These are serious and the court has to look at that. I have to look at all of the Polk County cases with the Burnett County cases combined. I do understand that he wants to get back to the house. That's a big deal and issue concerning Mr. Anley and Ms. Hess in their underlying marital matter, their divorce. There's outstanding other matters, and Mr. Anley has filed a motion in the divorce matter concerning the house and those kinds of things, which is on hold right now until other things get kind of smoothed out or worked out, and so he can be able to present that to the court. But that's there and it's held, Mr. Anley. Again, these are serious and I have to combine all of that. It's not just about your ability to appear in court. So based upon the seriousness, I will modify bond and I will amend it lower. It is now set at 18,000, but the court has to ensure not only that he's going to come to court, but look at all of the other factors and all of the other cases. So the court will lower it to a total of $10,000. I believe he has 3,000 posted. So it would be an additional $7,000, at least at this time, due to the seriousness of the case. And again, I don't know what's happening in our 25 case. I know that you have presented an agreement. I don't know what's going to happen in the 26 case. All factors come into play as it relates to bond, obviously. So the court will amend it down to a $10,000 total. Same conditions are applicable. Okay.
Yes,
Anything further?
Not from my perspective, Judge.
All right, then we'll see you on Monday. Mr. Fisher, please meet with Mr. Vila so that you can discuss anything else further, okay?
And what time was
Oh,
that
did I
hearing?
not? I did not give a time. Sorry. I could do Monday at 9:45. Or Thursday at 11:30, if that works better. Getting close here with time.